Let us now proceed with the procedures for regular preliminary investigation. Okay? So, ano po ba yung step-by-step process? So, let us try to discuss. No? So, first, the receipt of original complaint affidavit with 2 duplicate copies. So, take note of this. So, ilang kopya daw po ang kailangan in prosecution office? 2 copies or 2 duplicate copies, and then dapat nandyan yung original. So, it is also accompanied by the duly accomplished NPS or National Prosecution Service Investigation Data Form or IDF na yan, no? Kasama po yan, no? In filing this complaint affidavit, and also accompanied by the affidavits of her witnesses as well as other supporting evidence. So yan po, no? Kapag na-file na po yan sa National Prosecution Office, what is the next thing that will happen? Okay, the head of the prosecution office shall ensure the sufficiency in the form of complaint affidavit in the completeness of evidence. So again, ano po ba yung titignan, no? So usually it answers the 5 W's and 1 H, no? So who is the accused person, no? If you are going to review, no, ano po ba yung sufficiency of a complaint affidavit? Nandyan po yung pangalan ng akusado, kailan nangyari yung krimen, saan nangyari, ano yung designation ng offense, kung yan ba ay murder, homicide, rape po ba yan, or physical injuries, and with the supporting evidence. So if the head of the prosecution office sees that it is incomplete, no, then he will require the offended party or the law enforcer or the public officer charged with the enforcement of the law violated, or in simpler term, the one who submitted or filed a complaint, he will require, no, or the head of the prosecution office will require them to submit any lacking pieces of evidence, no. Ngayon, if nakita nila kompleto, no, so sapat yung mga na-submit sa kanila, meron original complaint affidavit na sufficient, meron yung NPS, investigation form, merong mga affidavits ng mga witnesses, and merong mga supporting evidences, then it will be docketed. Or in other words, it will be already put in the line. Or in other words, yan po ay may isasama na dun sa nakalinya, kumbaga, na isa-subject na for preliminary investigation or for inquest proceeding or for further procedure. Okay? Or uusad na po yung kaso. So, kumbaga, mailalagay na siya sa listahan, maisasama na siya sa listahan, or mailalagay na po siya sa line-up or sa pila, or in simpler terms po yan ng docketed. So, take note also, if the respondent is a child in the conflict of the law or CICL, lagi po nating tatandaan, special po yung case na yan, and meron pong provisions ang RA 9344 na susundin nila in the conduct of PI. So, hindi po mag-e-effect ang DC number 28 na ito or DC number 15 ng DOJ na rules kapag bata daw po or CICL yung involved, okay, sa kaso. Take note of that. Next. So, within 5 calendar days upon receipt or from receipt of the entire records, no, okay, so the prosecution may either recommend, no, dismissal. So, 5 calendar days ang naibigay sa kanila, no. So, dismissal kapag walang grounds, no, or in other words, wala pong prima facie evidence, no. So, within 5 calendar from its receipts of the entire records, dapat simulan nilang tignan kung i-dismiss ba. But since there is no ground or there is no prima facie evidence with reasonable certainty of conviction. If there is, then they shall issue corresponding subpoena to the parties to appear before him, no, for preliminary investigation hearing. Take note, if there is a reasonable ground. Okay? So that is on this part. Next, so take note in this part that the subpoena shall set the date, time and place of for appearance of preliminary investigation hearing. Syempre, para alam niya kung saan siya pupunta, kailan siya pupunta, no? Well, which shall not exceed 30 days from the investigating prosecutor's receipt of the entire records, or hindi po aabot yung palugit para dun sa subpoena ng 30 days. Okay? So, mas mababa po ng 30 days. Pwede po nating ibigay na palugit dun sa tao or dun sa inaakusahan para magpakita dun sa magpakita po sa office for the conduct of the hearing. No? So, the subpoena to respondent shall include the complaint affidavit. Ito po yung mga attachment na ipapadala sa kanya. Each attachment, no, complaint affidavit, attachment, and shall direct the respondent to submit his/her counter affidavit or affidavit of his/her witnesses on the date set for the purpose, no, or dadalhin niya during or on the mentioned date of the subpoena, no, which must be at least 10 days from the receipt of the subpoena. So 10 days para mag-submit naman. So kapag submission of the counter affidavit, 10 days po yung palugit. Okay? From the receipt of the subpoena. So, take note. Paano naman daw kapag voluminous records? Okay? Voluminous. No? Ibig sabihin po parang marami po yung record kumbaga. No? So, hindi po siya kaya sa 10 araw. No? So, pwede naman po na more than 10 days. Okay? Kasi 10 days kapag yung regular. No? Pero kapag yun nga, maramihan daw yung records na hinihingi, then it may be not less than 10 days. Okay? But take note, it should not be more than 30 days. So, where there are pieces of object evidence, the respondent shall be given the opportunity to examine the same. No? So, if there is an involved object evidence, the respondent may examine the object evidence presented by the other party. He may also allowed to take photographs. Okay? So, ano ba yung preliminary investigation hearing or what is going on there? So, the respondent shall file his/her counter affidavit, and the respondent or his/her authorized representative shall file the original copy of his/her counter affidavit of 2 duplicate copies, no, for official file with the prosecution office, and furnish a copy to the complainant or each complainant. So, on the preliminary investigation hearing, the personal appearance of the respondent during preliminary investigation may be dispensed or pwedeng hindi siya magpunta. Ano yung kailangan? Pwedeng i-allow yan kapag yung counter affidavit niya ay napanumpan niya yan. It was subscribed and sworn before any prosecutor and or any government official, or kapag yan ay napa-notarize niya. No? So, yan po ay pwedeng wala ng personal appearance si respondent if meron siyang counter affidavit daw na na i-subscribe niya and sworn under prosecutor or government official authorized to administer a note, or it is notarized in the absence of the latter. Okay? So, if the respondent does not appear, no, the investigating prosecutor shall require proof of the complainant that the respondent's address in the complaint affidavit or in the PS-IDF is the respondent's last known address. So, kung titignan nila kung talagang tama ba yung address, dyan ba talaga nakatira. Okay? So, ngayon, ano pa yung titignan nila kapag hindi nag-appear yung subject? So, kapag despite of the receipt of the subpoena, no, of her last known address, no? So, na-receive niya yung subpoena, or the respondent fails to appear or file her counter affidavit without any justifiable reason on the time that was given to him, no, the investigating prosecutor may consider the case submitted for resolution. Or in other words, when we say resolution, kumbaga yan po yung judgment, no? Judgment ni prosecutor. So kung sa court, meron po tayong tinatawag na judgment na binibigay ni judge, no? Meron din naman pong decision na tinatawag natin si prosecutor na tinatawag nating resolution. Okay? So he will arrive at a resolution after doing those procedures. So the investigating prosecutor, after receiving the counter affidavit and after ensuring that the complainant has been furnished a copy thereof, may either consider the case submitted for resolution also. Next, when there are facts and issues to be clarified from a party or a witness, they set a case for a physical or virtual clarificatory hearing. No? So it is a procedure in order to resolve issues regarding those documents that they have presented. So within 10 calendar days from the said receipt, there will be that is the time frame for the conduct of virtual clarificatory hearing, no, or physical or face-to-face clarificatory hearing. So attendance of both complainant and respondent shall be mandatory. So whether physical or face-to-face, mandatory. On virtual, mandatory. Next, so during the clarificatory hearing, the investigator may perform any of the following: ask clarificatory questions or have the case submitted for resolution, require the filing of reply affidavit or a rejoinder affidavit. So again, reply affidavit, response po yan ni complainant dun sa counter affidavit ni respondent. Okay? So ngayon, kapag naman yung rejoinder, yan po yung response ni respondent dun sa sinabi ni complainant dun sa reply affidavit. Okay? So take note, the prosecutor may require the filing of reply affidavit if the counter affidavit, no, contains new issues of fact or questions of the law. No? So he can only require the other party to file a reply affidavit if the counter affidavit meron silang mga bagong issue na binanggit doon. No? So hindi lang nila sinagot yung mga akusa natin doon sa complaint. No? But meron din silang sinabi na, or meron naman silang mga nilagay na akusa laban sa atin or ni-raise na issues doon sa counter affidavit. Then the prosecutor, i-require niya, kailangan yung mag-file naman, o kayo mga offended party, kailangan yung mag-file ng reply affidavit para sagutin ninyo yung mga akusa or bagong mga issues na ni-raise ng respondent sa kanyang counter affidavit. Okay? Kapag and then syempre on the reply affidavit, there should be the rejoinder affidavit naman ng respondent. Okay? In no case shall the filing of the reply affidavit and rejoinder affidavit be more than 10 calendar days. So 10 calendar days usually that is being observed in the submission of affidavits. No? And the rejoinder affidavit shall be the last pleading allowed. Wala na po, no? So wala na pong sumbat doon sa rejoinder affidavit, kaya 4 po yung sinabi natin kanina. Okay? Next. So take note, at any time during the preliminary investigation but before the case is submitted for resolution, the prosecutor may, upon motion or motu proprio or on his own, may issue subpoena ducesticum or may require a person. So ducesticum require a person to produce documents or present documents they need, no? Or ad testificandum or require the person to attend, no? So this is for the person, this is for a document, no? Document ang nire-require ni prosecutor na i-submit. Pero dito tao, no? Subpoena na ad testificandum, yan po ay tao yung nire-require niya na mag-present mismo sa harapan niya. To require either of the parties or any of the witnesses, including third parties, private individuals or offices or government officers and offices, to produce books, records, documents, evidence, or execute sworn statement that are material, okay, or merong kinalaman doon sa krimen at merong direktang pinapatunayan doon sa krimen na iniimbestigahan ni prosecutor. Okay? Prosecutors may initiate criminal complaints under Article 151 kapag ito yung magiging kaso na natin kapag hindi natin sinusunod yung subpoena or utos or order ni prosecutor. Yan. He may file a case of resistance and disobedience to person in authority or the agents of such person. Take note, a prosecutor is a person in authority. That's why, pag hindi po natin sinunod, we are liable or on Article 151, or that is resistance and disobedience to a person in authority or agents, okay? Or halimbawa, mga law enforcers, no? Okay? And as amended by the PD number 1829. Okay? Or in other words, yan po ay obstruction of justice. Okay? So, hindi lang po yan. Kahit ano po na makita na kaso or pwedeng ikaso ni prosecutor, pwede niyang i-file. So, take note also that there is no motion to reopen preliminary investigation shall be entertained unless justified by the circumstances. Ano po yun? Yung mga scenarios such as when there are newly discovered pieces of evidence, no, that has substantial value for the investigation, no? Pero kapag wala namang newly discovered evidence, then hindi po papansinin niyang reopening na yan. Pero kapag merong nakitang bagong ebidensya, then a PI may reopen. A motion to conduct a motion to reopen the PI is granted. So the preliminary investigation may also be reopened through a motion, no? When the complainant or respondent failed to participate in the proceedings due to the non-receipt or belated receipt of the subpoena, no? Or napatunayan na okay, talagang merong valid reason ay hindi po natanggap ni complainant or ni respondent lahat ng mga proceedings or mga subpoena na pinadala ni prosecutor, then pwedeng ma-reopen yung preliminary investigation, or they may file a motion to reopen the PI by reason of the non-receipt of the subpoena. Okay? So, ano po ba yung procedures ng virtual preliminary investigation? So, mag-a-apply din naman yung mga nasabi doon sa Section 10, particularly paragraph A to E, no, na binanggit natin kanina, or yung na-summarize natin kanina. So, ngayon, after those stages, then if the prosecutor finds the conduct of virtual preliminary investigation will be beneficial to a fair, speedy, and efficient administration, then they are going to follow this procedure, no? So, before the initial or regular face-to-face preliminary investigation hearing is terminated, they shall issue an order stating that the parties opted or pumayag na ipagpatuloy yung proceedings or PI through video conferencing or virtual platform. Okay? So, ano ngayon yung nilalaman ng order na ipapasa nila prosecutor? No? So, the official email addresses, contact details of the prosecution office, the prosecutor, the parties and their witnesses, and counsel. Take note that official email addresses or yung ginagamit nila talaga in the performance of their duty. Okay? Or active email ng bawat parties. No? So, the date and time of the clarificatory hearing, no? Kapag meron silang mga issues na gustong sagutin or erase, no, or i-clarify, then they are going to have clarificatory hearing, or the e-filing and e-service of pleadings, whichever is applicable. So the date and time of the submission of hard copies of documents to the prosecution office, no? So which shall not be more than 3 calendars prior to the video conference hearing. Okay, take note, hard copies are also needed, no? The date and time of video conference hearing, the access or details, katulad na lang po ng link or passcode for the video conference platform, katulad po ng Zoom, no? Google Meet, pero yung nabanggit po specifically sa Department Circular, Zoom, which is the most availed. Such other matters as may be necessary to define the parameter of the video conference hearing. So the parties shall sign also the order as a proof of their conformity thereto. Huwag po natin kalimutan, papirmahan sa bawat party, no? The investigating prosecutor shall ensure that the schedule for clarificatory hearing or the e-filings, as the case may be, complies with the period prescribed in Section 10, paragraph F to H, usually around 10 calendar days. So if the respondent fails to submit his/her counter affidavit during the initial hearing, an extension is granted on meritorious ground. The e-filing of the same may be allowed, provided that the same shall not exceed 10 days. So e-filing, or in other words, through email. So the filing of counter affidavit, in case an extension is allowed, or when deemed necessary, the reply affidavit or rejoinder affidavit shall be made electronically via email again, no? Prior to the said e-filing of service, the submitting party shall have his or her affidavit or the affidavit of his or her witnesses subscribed and sworn to before any prosecutor or government official authorized to administer, or in their absence of an availability, before a notary public and has jurisdiction over the residence of the affiant. Okay? Thereafter, the electronic copy in portable document format, again PDF, no, non-editable form, okay, of the subscribed and sworn affidavit shall be submitted through email to the official email addresses contained in the order, or yan po yung sinabi natin kanina na official email addresses ng prosecution office. So the hard copy, no, or the PDF copy of the counter affidavit or reply rejoinder affidavit shall separate from the PDF copies of each of the accompanying documents, no? Separated po yung tatlo. The file name of each document shall pertain to the respective title or description, no? Siyempre, maging organized po sa pag-file. Pangalanan natin, counter affidavit of who, no? Reply affidavit and rejoinder affidavit. All PDF copies of documents must be completely legible or naiintindihan, okay? Or nababasa. Baka hindi naman makita kasi meron yung mga e-files na ang liliit ng sulat, di mabasa, di maintindihan. So documents that are e-filed in e-serve beyond office hours are deemed filed and served on the same day, okay? Take note of that. So nag-file po tayo ng madaling araw na or midnight, no? Then kung ano yung date na yun, that is considered filed on the same day. So the hard copy of the original affidavit and 2 duplicates shall be submitted to the prosecution office. So aside from emails, there should be hard copies, no, that will be submitted to the prosecution office. Personally or by, pwede na daw ang ipa-deliver. Pwede nang by accredited courier or on or the schedule set in the order. Okay? So, pwedeng ipadala or pwedeng personally na ipasa sa prosecution office. So, the party submitting the hard copy shall likewise file a verified declaration that The electronically filed affidavit and accompanying documents, if any, are complete and true copies of the hard copies filed in the prosecution office. So during the video conferencing also, the investigating prosecutor shall require the affiants to reaffirm their oath in their affidavits. Also, the prosecutor shall personally examine the affiants and may ask questions that can aid in the investigation and the resolution of the case. So all video conferencing, take note, are always recorded. Yan yung kagandahan niya. Kasi kapag face-to-face, minsan hindi yan na re-record. Pero kapag video conferencing, recorded yung hearing. Okay? Failure to timely file an affidavit via email and to submit the hard copies thereof with the required verified declaration shall be deemed a waiver of the party's right to do so. So, electronic copies of the affidavits or of any accompanying document not in the PDF or in the PDF but not legible or hindi makita, hindi mabasa, hindi maintindihan, or are protected by a password or other encryption or with embedded executable code or scripts or are otherwise corrupted shall not be considered as having been filed and therefore excluded from the records of the case.